if they believe you have information, they arrest you and they take you to a secret trial hearing before a judge. Okay, this is from page 3. So they're amending all these things. This is other changes. Bill S-7 also modifies section 7 subsection 2 of the code, which describes various acts and omissions in relation to aircraft, airports, and air navigation facilities taking place outside Canada that are also considered terrorist activities under section 83.01 subsection 1A of the code. In addition, the bill introduces into the code several new terrorism related offenses, okay, all involving leaving Canada or attempting to leave Canada for the purpose of committing certain other terrorism offenses. The bill also increases the maximum penalty under the code for harboring or concealing a person who has carried out a terrorist activity where the purpose of the decision to hide the person is to enable him or her to facilitate and carry out terrorist activity. Currently, the offense of harboring and concealing carries out a maximum penalty of 10 years imprisonment. Bill S-7 increases that penalty to 14 years in circumstances where the person being hidden has committed a terrorism offense punishable upon conviction by up to life imprisonment. Okay. Here's some more, page 6. It says, because section 7 subsection 2 of the code is incorporated by reference into the definition of terrorism activity found at section 83.01 subsection 1A of the code, the acts or omissions described in section 7 subsection 2 of the code, as well as threats, counseling, or attempts to commit them, also constitute terrorist activity, which we're going to go into what is the terrorist activity, because that's one thing me and the brother Daniela from the camp were discussing, and I had to research that because they vaguely describe what terrorist activity is. You have to actually go into the criminal code, which through the spirit of Yahweh Hashem Yahshai, I found out, I looked it up, and it's not good news for the men of the Lord. Alright, I'll tell you that. So it's imperative that brothers in Canada take heed to this, right? Because this affects you. Page 8, it says extension of specialized electronic surveillance and warrant provisions. It says the Terrorism Act introduced amendments into the code which made it easier to use electronic surveillance to intercept the communications of those for whom there are reasonable grounds to believe that they have committed or will commit terrorism offenses. The amendments are also made it easier to collect DNA from them. It says, with respect to electronic surveillance, the Anti-Terrorism Act amended the code's wiretap provisions so that the investigative powers introduced in 97 to make it easier to use electronic surveillance against criminal organizations could also be used to investigate the terrorism offenses described above. Alright? It says the changes had the effect of extending the period of validity of a wiretap authorization from 60 days to up to 1 year when police are investigating a terrorism offense, and permitting a delay of up to 3 years in notifying a target after surveillance has taken place, as opposed to the 90-day period that is applicable for other criminal offenses. Alright. It says this is clause 14 of Bill S-7, adds the 4 new offenses found in clause 6 to 8 of the bill to section 183 of the code. Section 183 defines the terms used in part 6 of the code, which among other things give peace officers the ability to apply to judges for warrants to intercept private communication of individuals when there are reasonable grounds to believe they have committed or will commit certain offenses. So it's on the, oh, I wonder, or, I think he will commit the offense, So they read all the codes here. Clause 14 ensures that wiretap provisions in the code applicable to criminal organization and other terrorism offenses found in the code also apply for these 4 new terrorism offenses. Right? Okay, this is page 11 under investigative hearings, which is a fancy word for, they arrest you when they have a secret hearing. So I'm going to read here, section 83.28 deals with bringing individuals who may have information about a terrorism offense before a judge for an investigative hearing. The objective is not to prosecute an individual for a criminal code offense, but to gather information. It says, under the provision, a peace officer with the prior consent of the Attorney General can apply to a superior court or provincial court judge for an order to gather information under the following conditions: if there are reasonable grounds to believe that a terrorism offense has or will be committed, if there are reasonable grounds to believe that information concerning the offense or the whereabouts of a suspect is likely to be attained as a result of the order, and if reasonable attempts have been made to obtain such information by other means. If granted, such a court order would compel a person to attend a hearing to answer questions on examination, and could include instructions for the person to bring along anything in his or her possession. The reenacted versions places more emphasis than did the original version on the need to have made reasonable attempts to obtain such information by other means, and it applies to past terrorism offenses as well as to potential future terrorism offenses provided for in the earlier version. The new version also emphasizes the court's obligation to compel an individual to attend the hearing for examination in the appropriate circumstances. It says the use of the word shall instead of may to ensure that any orders made under section 83.28 subsection 5 compel an individual to attend a hearing resulted from one of the recommendations of the House of Commons subcommittee. It says, in addition, 83.28 states that any person ordered to attend an investigative hearing is entitled to retain and instruct counsel. The person will be required to answer questions and may only refuse to do so on the basis of laws relating to disclosure or privilege. The presiding judge will rule on any such refusal. No one called to such a hearing can refuse to answer a question or to produce something in his or her possession on the grounds of self-incrimination. However, any information or testimony provided by an individual during a hearing cannot be used against him or her in a subsequent proceeding except in relation to prosecuting him or her to perjury or for providing subsequent contradictory evidence in a later proceeding. Okay, so that was on the investigative hearings, and this is page 12, 2.1.7, recognizance with conditions / preventative arrest. And it says, Clause 10 of Bill S-7 also reenacts Section 83.3 of the Code dealing with recognizance with conditions and preventative arrest to prevent a potential terrorist attack with substantially similar provisions. Under this reenacted section, with the prior consent of the Attorney General, a peace officer may lay an information before a provincial court judge if he or she believes that a terrorist act will be carried out and suspects that the imposition of a recognizance with conditions or the arrest of a person is required to prevent it. The judge may order the person to appear before any provincial court judge, whereas the original version of this section stated that the judge could order the person to appear before him or her only. This change is similar to one suggested by the House of Commons subcommittee. If the peace officer suspects that immediate detention is necessary, he or she may arrest the person without a warrant, either before laying the information or before the person has had a chance to appear before a judge. So the person who has been detained must be brought before a provincial court judge within 24 hours or as soon as is feasible. The original wording referred to as soon as possible. At that time, a show cause hearing must be held to determine whether to release the person or to detain him or her for a further period. This hearing can be adjourned for a further 48 hours only. The Special Senate Committee amended this provision in '03 during its review of Bill S-3 in order to narrow the wording, setting out the grounds on which an individual may be detained. Okay, and these devils are all about words. That's why the elders push you. Alright, push us to go into words, man. You got other groups out there, they don't give a shit about words. That's good for them. Alright, so that was the legal aspect. Alright, like I said, it's 2 books. It's this and this, basically. You know, it's 2 PDFs. Now I'm going to go to the Criminal Code of Canada, which is again another public document. Alright, Government of Canada, navigation bar. You can go on the website. Alright, as you see, this is all official. So now we're going to look at what is terrorist activity, because they kept mentioning terrorist activity. So this is section 83, because they kept mentioning 83. Alright, as we took notice, they kept mentioning section 83. So this version of section 83.1 is enforced from 2011 to 2013 04/16. Alright, as you see here, terrorist activity means, and I have the important parts highlighted down here. Alright, section B, A, it says in whole or in part for a political, religious, or ideological purpose, subjective or cause, and B, in whole or in part with the intention of intimidating the public or a segment of the public with regard to its security, including its economic security, or compelling a person, a government, or a domestic or an international organization to do so, or to refrain from doing any act, whether the public or the person, government, or organization is inside or outside of Canada, and that intentionally causes death or seriously bodily harm to a person by the use of violence, endangers the person's life, causes a serious risk to the health or safety of the public or any segment of the public. Okay. E, causes serious interference with or serious disruption of an essential service, facility, or system, whether public or private, other than as a result of advocacy, protest, dissent, or stoppage of work that is not intended to result in the conduct or harm referred to in any of the clauses. Section 1.1, for greater certainty, the expression of a political, religious, or ideological thought, belief, or opinion does not come within paragraph B of the definition terrorist activity in subsection 1 unless it constitutes an act or omission that satisfies the criteria of that paragraph. Okay, so that was, I believe that was it. Yeah, so that was it basically. So, as you've seen, they deemed the black Israelites as a religious group, of course. You know, or they can put an ideological, whatever. Alright, and before we had the police tell us that we were a danger to the public, or we intimidate the public because people talk, you know, bring in false reports, man. So the point is, this is the real thing, you know, and the brothers in the truth, and up here in Canada, you know, you should be well aware of these things. So it gives you more reason to pray to Yahweh Shem Yahushai, you know, and follow his words that you have to be wise as a serpent and harmless as a dove. You know, so with that, I hope you brothers are edified, and Yahweh Shem Yahushai willing, till next time. You know, I want to give all praises to Yahweh Shem Yahushai. Double honors to the elders that rule well. Alright, and you know, shalom to the elect, the true men of Yahweh Shem Yahushai. Shalom.